नमस्कार. आयच्या ह्या खाशेल्या ग्राउंड झिरोक तुमकां सगळ्यांक येवकार. आज हो ग्राउंड झिरो करपा फाटलें कारण म्हळ्यार सुप्रीम कोर्टाची ऑर्डर. आनी काल वर्डिक्ट कोर्टा भितर प्रोनावन्स जातकीर आमी कंटिन्युअसली सांगताले की रिटन ऑर्डर कितें येता ती पळोवया. तातूंत भितर आमकां चड गजाली स्पश्ट जातल्यो आनी तशीच परिस्थिती आसा. रिटन ऑर्डर आयल्या सुप्रीम कोर्टाची. कितें आहा ह्या रिटन ऑर्डरी भितर, ताजी इम्प्लिकेशन्स कितें, आनी फकत गोंया खातीर न्ही जाल्यार पुराय देशा खातीर ती कितली म्हत्वाची. आनी गोंयचे जे राज्यकर्ते आसात ते आज एकटो आसतलो, फाल्यां दुसरो आसतलो, तांणी कितें मतींत दवरपाक जाय. म्हजे बरोबर आज म्हाका जॉयन करतात इन दीस स्पेशल ब्रॉडकास्ट आमचे लिगल रिपोर्टर मुकेश कुमार. मुकेश, वेलकम. आणि विदाउट वेस्टिंग एनी टायम वी आर गोईंग टू दी सुप्रीम कोर्ट ऑर्डर. कितें आहा ह्या लेखी ऑर्डरी भितर तें जाणून घेवया. आमकां मेजर जे पॉयंट्स आशिल्ले ते आमी कालच्यान तुमकां सांगताले. बट 96 पेजीस 96 पानांची ऑर्डर आसा. म्हळ्यार तुमकां लक्षांत येतलें की ह्या ऑर्डरी फाटलें गांभीर्य कितें आसता. आनी तातूंतले ह्या 96 पानांतले ह्या 96 पेजीसांतले कांय एक्सर्ट्स जे अत्यंत म्हत्वाचे आसात, जाची रेमिफिकेशन्स आनी इम्प्लिकेशन्स सगळ्यां खातीर म्हत्वाची आनी कितें म्हणटा ही सुप्रीम कोर्टाची ऑर्डर. सो मुकेश, वील स्टार्ट विथ व्हेरी व्हेरी बेजीक थिंग एंड तुमकां हांव दाखयता की कितें आहा तें. सगळ्यांत पयलीं जी आमची तुमकां हांगा पळोवपाक मेळटलें ऑन दीस बीग स्क्रीन जो पॉयंट येता, हांव वाचून दाखयता, देन वील गो इन टू द डिटेल्स ऑफ दीस. पयली जी स्लायड आसा, ऑल 9th and 12th February immediately challenging the director's order dated 4/2/2021. just context 4 तारखेक रिजर्वेशन आणि डिलिमिटेशनाची ऑर्डर आयिल्ली आणि ती ऑर्डर येतकीर विदीन 4-5 days 9 आणि 12 ह्या तारखां मदीं चॅलेंजिंग दीस डिलिमिटेशन आणि चॅलेंजिंग दीस रिजर्वेशन ही ऑर्डर आयली. नन ऑफ दीज रिट पिटिशन्स कंटेन्ड अ प्रेयर दॅट वूड होल्ड अप एनी इलेक्शन प्रोग्राम. ह्या सगळ्या पिटिशना भितर कोणेच अशी मागली नाशिल्लें की इलेक्शन होल्डार दवरात म्हणून. रिजर्वेशन आणि डिलिमिटेशन सारकी करात इतल्या पुरतोच हे मुद्दो आशिल्लो. The only prayer was to strike down the aforesaid order, which is of 4th February, so that the director in issuing a fresh order would have to truly and faithfully carry out the constitutional mandate of Article 243T of the Constitution of India and the statutory mandate contained in Section 9 of the Goa Municipalities Act. Next, one point I complete kariya, then I will talk to Mukesh about this. When the High Court issued notice on 15/2/2021, now this is very interesting, की 15 फेब्रुवारीक जेन्ना हायकोर्टान ह्या पिटिशन्सांची दखल घेवन जेन्ना नोटीस इश्यू केली फॉर फायनल हियरिंग ऑन 22nd February, the State Election Commission did not inform the High Court that wide a note of 5/2/2021 आणि एक व्हेरी इंटरेस्टिंग, आणि हे सुप्रीम कोर्टाच्या ऑर्डरी भितर ब्रॅकेटां आसा म्हणून आमी तशा तशी ब्रॅकेटी भितर घाला. disclosed for the first time by an affidavit filed in this court on 8/3/2021 that elections were proposed to be held on 23/2021. हाजो अर्थ की 22 तारखेक जेन्ना फायनल हियरिंग हायकोर्टान ऑलरेडी फिक्स केल्लें आनी त्या टायमार जेन्ना हियरिंग घेतिल्लें आनीक सांगिल्लें की आमी 22 तारखेक हो मॅटर आयकता म्हणून, तेन्ना सुद्दां स्टेट इलेक्शन कमिशनान हायकोर्टाक इल्लो सुद्दां वास लागपा दिलो ना की ज्या दिसाक हायकोर्टाचें हियरिंग आसा त्याच दिसाक सकाळीं हायकोर्टाची प्रोसिडींग स्टार्ट जावच्या पयलीं इलेक्शन डिक्लेअर करपी नोटिफिकेशन काडटले म्हणून. सो तो जो ब्रॅकेटांतलो भाग आसा, disclosed for the first time by an affidavit filed in this court on 8/3/2021. हें अत्यंत महत्वाचें. Mukesh, tell me one thing, how important is this observation? And I think this is the first major observation in that order. So do you think Supreme Court also considered, I think what High Court considered in that order also was the notification of election was issued on the same day at 9 a.m. to somehow subvert the process, judicial process in the High Court. Do you think Supreme Court has agreed with that basic argument that the notification of election was issued only to subvert the judicial process by saying that हमने process शुरू कर दिया है, now you can't interfere?
Yes, one paragraph I want to read it out of the Supreme Court judgment, which says rather scrutinize the act of the State Election Commission and the Goa government. It is like this. First and foremost, it is important to note that the State Election Commissioner is none other than the Law Secretary to the Government of Goa. The whole process of these elections is therefore faulted at the start. So to speak as the State Election Commissioner is not, in fact, in these cases an independent body as it is mandated by the Constitution of India. So Supreme Court has critically analyzed the timeline, as you mentioned right now, that how the election was declared. On 4th of February, in one day the entire process was taken up to notify the reservation. And when the matter was came up before the High Court, when the petitions were filed between 9th Feb and 12th Feb, nobody was, though State Election Commissioners Council were present before the High Court, but nobody said anything about the election date. So High Court issued notice for the final disposal very next week. 7 days time was given. I remember that Advocate General asked one more day, saying that on 22nd he will file the affidavit and give 1 day time to the petitioners to file rejoinder if any. But High Court said no, we will take up this matter on 22nd February. So you can understand that how much High Court considered it important matter. But before that, on 22nd Feb only, High Court has changed its timing. Now it starts at 9 a.m. and usually government offices open at 10 or 9:30. So High Court and Supreme Court mentioned that matter was scheduled before the High Court for hearing at 9 a.m. So notification was issued before that, and the copy of notification was given to its counsel, which was presented about at 9:30 when the matter came up for the hearing. So entire process, Supreme Court and before that High Court, both understood that the act of notifying the reservation and then the notifying the election date was just to overreach the High Court and High Court proceeding. So this is very critically taken up by the Supreme Court, and Supreme Court has held that okay, fine. And one more thing I am telling you, the important part in this matter. You remember when the final hearing was happening before the High Court, Advocate General made the statement that he will not take the plea that election has been notified, and he will talk about the merit of the every matter. It was done by him also, but Supreme Court has made a clear observation. When the matter came up before the Supreme Court, Advocate Tushar Mehta, Senior Advocate Tushar Mehta was representing state government. And Tushar Mehta mentioned that assurance was given by the Advocate General that the state government would not raise the bar of Article 243G, but it would instead argue that since the election program was imminent, means election, he had given the assurance that he will not take that plea. But Supreme Court mentioned that there cannot be no doubt that no concession by the council can operate against a constitutional bar. He was saying that there is constitutional bar that once the election is notified, no court should intervene. But a council or Advocate General cannot give that concession to the court because a principle is set. So High Court has taken that consideration, but Supreme Court said no. Advocate General cannot give that concession.
Yeah. Next is a very, very interesting paragraph from this order. And paragraph that after the judgment was pronounced by the division bench of the High Court on 1st March and no stay granted, this court, means the Supreme Court, issued notice. Now this is a very important. हांवें कित्याक सांगता की जशी ब्रॅकेट सुप्रीम कोर्टाच्या ऑर्डरी भितर आशिल्ले तशी हे इन्वर्टेड कॉमास जे आसात इशूड नोटीस म्हणून ते इन्वर्टेड कॉमास सुप्रीम कोर्टाच्या ऑर्डरी भितर आसात. Issued notice on 4th March and stayed the impunged judgment, the effect of which was to revive the election program that was notified on 22nd February. Despite this, the State Election Commission on this very day, that is 4th March, on the same day, ज्या दिसाक Supreme Courtan सकाळी ती technical stay दिली, on the same day, 4th March, amended the aforesaid notification by extending the time period for filing of nomination for 5 municipal council from 4th March till 6th March between 10 a.m. to 1 p.m. and therefore rescheduled the election. आता हातूंतली important गजाल एक सामकी आनी एक very crucial आनी ती गजाल कितें की जे त्या दीस आमी ग्राउंड झिरो जो केला, on that ground zero many panelists said, many experts said that election commissionaक इतली घाई कित्याक. जेन्ना सुप्रीम कोर्ट म्हणटा की आमी मंगळाराक फायनल डिस्पोजला खातीर केस घेतात तेन्ना परत रिवायव करपाची घाई कित्याक हें नोटिफिकेशन. आनी तें ऑब्जर्वेशन बरे तरेन सुप्रीम कोर्टान हातूंत भितर मांडलां. Mukesh, that went against the SEC. If you read this paragraph, you feel that that went against the SEC, that we gave a technical stay. That's what the Supreme Court is saying. And you took that opportunity to revive the election program when we are supposed to dispose of the matter. Do you get that sense?
Yes, of course, Supreme Court has mentioned also that due to pandemic, the election was postponed, and it was postponed for the notification issued by the State Election Commission says that we are postponing this election till April 2021, or when the State Election Commission feels that it can be hold up. So Supreme Court says that you have given the first timeline of April 2021. Then why you thought to hold up this election on 20th March. So again, timing altogether, it says that on the there is no direct line as such, but it seems that on the direction of the government, State Election Commission or commissioner more particularly has acted in this matter. So when you have timing till April, then why you are hurrying? And another thing I'm again telling you, the amendment which was said that 3 weeks time will be given after the notification of reservation and delimitation, then the date of the election will be notified. But in this case, on 4th of February, the notification was issued for reservation, and same day, there was an amendment in the Goa Municipality Act, reducing that 21 days time frame to 7 days.
Yeah, so again trying to go against and legislatively against the order of the High Court. Next point, very, very crucial. आणि हें अखा टायम लागतलो वाचपाक म्हाका, पूण हांव वाचून दाखयता कारण हाज्याकी इम्पॉर्टंट पॅरेग्राफ म्हाका दिसता ह्या ऑर्डरी भितर ना. The most disturbing feature of these cases is the subversion of the constitutional mandate contained in the Article 243K of the Constitution of India. The State Election Commissioner has to be a person who is independent of the state government, as he is an important constitutional functionary who is to oversee the entire election process in the state and panchayats and municipalities. The importance given to the independence of a state election commissioner is explicit from the provision for removal from his office made in the proviso to clause 2 of the Article 243K. Insofar as the manner and the ground for his removal from the office is concerned, he has been equated with a judge of a high court. Very, very important. Next. Giving an additional charge of such an important and independent constitutional office to an officer who is directly under the control of the state government is, in our view, a mockery of the constitutional mandate. We therefore declare that the additional charge given to a law secretary to the government of the state flouts the constitutional mandate of Article 243K. The state government is directed to remedy this position by appointing an independent person to be the state election commissioner at the earliest. Such person cannot be a person who holds any office or post in the center or any state government. Important, such person cannot be a person who holds any office or post in the central or any state government. Next. It is also made clear that henceforth all the state election commissioners appointed under Article 243K in the length and breadth of India, have to be independent persons who cannot be persons who are occupying a post or office under the central or any state government. If there are any such persons holding the post of state election commissioner in any other state, such persons must be asked forthwith to step down from such office, and the state government concerned be bound to fulfill the constitutional mandate of Article 243K by appointing only independent persons to this high constitutional office. I think this is very clear. म्हाका दिसता इतलो स्पष्ट हो ऑर्डर इतलो भाग आसा की जो बेंच बशिल्लो आयकुपाक तांकां दिसलें की कोणाकच आनी इंटरप्रीट करपाक आनी स्कोप दवरपा नाका, इतली स्पश्टपणान ताणें दवरला. मुकेश विल गो पॉइंट बाय पॉइंट, बट फर्स्ट, do you feel the same thing that this is so elaborately written on this one concept of independence of the state election commission and state election commissioner that even the Supreme Court did not want to give any scope for interpretation to any government?
Of course, Supreme Court has mentioned the power of a state election commission, said that he has been, or whoever, it has been equated with the judge of the High Court. It means how independent and how powerful you are, you can consider. And it gives you not only power, but the responsibility to hold free and fair election. So, this is the observation of the Supreme Court, and which is why the Supreme Court immediately said to remove or step down every state election commission across country who is having SEC as additional post. So it obviously, be it High Court or be it Supreme Court, everybody wants, or our constitutional mandate is the state election commissioner is in an important post and he has responsibility. So any government servant must be in conflict with the interest if holding the constitutional post, and at the same time he is a government servant. So I don't know why this order was issued by the governor of Goa. So before appointing state election commission, I think governor of Goa should have also applied mind that additional charge should have been given or not, and there was no hurry. Suppose sometime what happens, finding appropriate person becomes difficult for the authority, so they may take time. But that time when the I think last year he was appointed. No,
that time cannot be so much that your elections come and still your law secretary is holding the office of the state election commission for that big time, that the elections are held under a law secretary of the government of Goa who is holding an additional charge as the state election commissioner.
And which is why on several occasions Supreme Court and High Court both observed that there was a fact which was hiding from the State Election Commission. As the Supreme Court mentioned that first time affidavit filed on 8th March, that election was supposed to be held on 20th March. I'm telling you, when the argument was going on before the High Court, the Council for State Election Commission mentioned that they want to hold this election on 20th March and counting will be on 22nd March because our assembly session is starting on 24th March. So they want to complete this process before assembly session. I don't understand that what is the problem with assembly session and why they want to complete the entire election process.
I'll come to that later after seeing the final observation of the Supreme Court. It's a very interesting question, Mukesh, ki assembly session asa, ye election commission kitak padna. We'll come to that. Before that, very important, anek म्हाका दिसता खूब important गजाली. Next. आणि हे इम्पॉर्टंट कित्याक म्हणटा कारण जेन्ना हायकोर्टान ती ऑर्डर दिली आमी सगळ्यांनी सांगिल्लें दिस इज अ व्हेरी व्हेरी मेरिटोरियस ऑर्डर एंड नॉट ओन्ली मेरिटोरियस दिस अ व्हेरी व्हेरी इंटेलिजंट ऑर्डर की हायकोर्टान खंयच अशें केलें ना की आमी इलेक्शन प्रोसेसाक इंटरफियर जातात आमी फक्त इलेक्शन प्रोसेस एक्सटेंड करतात सो दॅट देर इज फेअर इलेक्शन फेअर रिजर्वेशन आनी हे आमी डे वन सावन सांगताले सो ताका लागून जेन्ना ही ऑर्डर हायकोर्टाची सुप्रीम कोर्टान अपहोल्ड केल्या सगळ्यांची तकल्या भितर एक आशिल्लें की हायकोर्टाच्या त्या ऑर्डरीचेर सुप्रीम कोर्टाचें ऑब्जर्वेशन कितें आसतलें काय का म्हण आनी तें जर पळयलें आय विल गो स्ट्रेट टू दॅट नो फॉल्ट कॅन बी फाउंड विथ द डिव्हिजन बेंच ऑफ द हायकोर्ट in ignoring any constitutional bar in arriving at the conclusion that the 4th February order is illegal and ultra vires the provisions of the Article 243T of the Constitution of India read with the sections of 9 and 10 of the Goa Municipalities Act. On merits, it is important to note that Shri Tushar Mehta, learned Solicitor General, did not advance any argument that the reservation of seats for women and OBCs was in accord with the provisions of the Constitution and the Goa Municipalities Act. Next. Indeed, even otherwise, we do not find fault with the division bench judgment in its conclusion that a fraction has to be worked upwards, whatever that fraction be, given the mandatory language of the Article 243T of the Constitution, which provides for reservation for women, which shall not be less than 1/3. Shall not be less than 1/3. Also, the findings of the High Court on OBC reservation not complying with the mandate of the section of 9(2)BB in that in several councils it was below 27% cannot be faulted. आता इतल्याचेर हे बरी हा गजाल but that last line is very crucial आणि म्हाका दिसता that last line in this observation should be a guiding light. जेन्ना आता परत प्रोसेस कर म्हणून सांगला तेन्ना परत आता केलं तशी अक्कल शून्यपण करनासतना पॉलिटिकल बॉसिसाच्यो गजाली आयकनासतना किती करपाक जाय एका सरकारी अधिकाऱ्यान जो त्या खुर्चेर बसला अर्बन डेव्हलपमेंटाचो डायरेक्टर म्हणून पहिली गजाल म्हळ्यार ताजे कडेन तो अधिकार आसपाकच जायना तो स्टेट इलेक्शन कमिशना कडेन आसपाक जाय आनी आज जेन्ना तो त्या मनशा कडेन आसा तेन्ना ताका इतली तरी तकली आसपाक जाय ती ही लास्ट लायन which says the same goes. This is very important. The same goes for the observations made on the first seat in Sange and non-application of the principle of rotation. हांगा आता सदांच जे म्हणटाले की वेग आसा रोटेशन हे एक प्रिंसिपल असो आसा तसो आसा आमी जाय तशी रोटेट करतात आमी जाय तो वॉर्ड काडून जाय थंय घालतात एकाच घरा भितर बापायची मत एक वॉर्डाक आवयची वॉर्ड एक वॉर्डाक मत एक वॉर्डाक ही जी फकाणां चलिल्ली आनी जी अजुनूय चल्लें आतां ही लायन आय थिंक नाव दिस इज इन द सुप्रीम कोर्ट ऑर्डर. And what does this line say? The same goes for observations made on the first seat in Sange and I think that those words, non-application of the principle of rotation, rotation हाचो अर्थ जर फाटले खेपेक जर वॉर्ड नंबर 3 रिजर्वड आशिल्लो फॉर विमेन, आता वॉर्ड नंबर 4 असपाक जाय, ताका रोटेशन म्हणटात. आणि आज सुप्रीम कोर्टाच्या ऑर्डरी भितर हो शब्द आयला, हे वाक्य आयला. मुकेश, हाऊ क्रुशल इज दिस? नंबर 1. नंबर 2, हाऊ मच इज दिस नाव अ गायडिंग लाईट for the officer who is going to redo the reservation of these 5 municipalities starting yesterday?
Pramod, it is very good line you have mentioned. And I'm telling you, you remember the Sangem ward number 1 was notified for OBC. And only one house of that reserved caste was in that ward. And DMA in its affidavit said that there has to be rotation. That's why we rotated and reserved for OBC. But the application of mind, that was not in the case of Margaon, where 2 wards were retained, saying that there are lots of population of that reserved caste. That's why we just retained. So one side you are rotating the seat, saying that it doesn't mean how many population are there. We are just following
irrespective
the
of the population you are rotating. In another municipality, because it suits you, you are coming up with a population argument and you are not even rotating it.
And defense was when the High Court and before that petitioners objected this, the defense was taking what? There is no set principle, there is no set policy. That's why DMA applied his mind. Which mind you are talking about? The High Court also asked that in the same matter, one side you are saying no, population doesn't matter, and another side in the same time you are saying that population matters. That's why we have retained that. So obviously it is
mockery. Tell me in simple words, does that line settles this dilemma once and for all? Supreme Court order says non-application of the principle of rotation, which clearly tells you apply the principle of rotation. Do you think, Mukesh, this settles it? This is a guiding light for the officer who is going to do the reservation again now?
100%. It is a not lesson. I could say that it is a slap. Whoever holding that post, who has the responsibility, they did not act.
Yeah.
And now again second chance have been given by the High Court and Supreme Court. And the person responsible must not repeat that mistake. Pramod.
Mukesh, thanks a lot. हांव इतल्याचेर थांबता एकाच कारणा खातीर की आमकां हे एक्सर्ट्स हाडून दाखोवपा जाय आशिल्ले की आमच्या राज्या भितर आनीक इलेक्शन प्रक्रिये भितर कितें चुकता हाचेर सुप्रीम कोर्टान कितें म्हणलें. आनीक एक इम्पॉर्टंट गजाल लक्षांत दवरात, सत्तेर खंयचोय पक्ष आसूं, आज एक आसतलो, घडये फाल्यां दुसरो आसतलो, की जनता म्हणून, लोक म्हणून आमी खंयच्याय राज्यकर्त्याक लोकशाही कडेन फोकाण करपाक दिवपाक जायना. आनीक एज सिटीजन्स आमी ती टॉलरेटूय करपाक जायना. आनीक जी गजाल सुप्रीम कोर्टान तरी आपल्या ऑर्डरी भितर टॉलरेट केली ना. आनी लास्ट बिफोर वी कंक्लूड, मुकेशान जो मुद्दो काडिल्लो की व्हाय एवरीबडी इज बॉदर्ड अबाउट द असेंब्ली सेशन. एकाच कारणा खातीर, कारण मुख्यमंत्री बजेट प्रेजेंट करपाचो आशिल्लो, अर्थसंकल्पीय अधिवेशन, जर आनीक ते बजेट 31 मार्चाच्या पयलीं प्रेजेंट जावपाक जाय. आनीक बाय एंड लार्ज आय थिंक प्रत्येकाच्या तकले भितर एक आसा की हें मुख्यमंत्र्याचें निवडणुकी पयलींचें विधानसभा निवडणुकीचे पयलींचें लास्ट बजेट. सो ह्या बजेटा भितर जशें 10,000 नोकऱ्यो बिकऱ्यो अश्यो खुबश्यो घोशणा जाल्यात, तशें आनी खुबश्यो घडये घोशणा करपाच्यो आसतल्यो. आनी त्यो जर करपाच्यो आसात, आनीक जर आतां इलेक्शनाचो प्रोसेस इज एक्सटेंडेड टील 30th एप्रील, जाल्यार कोड ऑफ कंडक्ट चालू उरतलो. ह्यो घोशणा करपाक अर्थमंत्र्याक मेळचे ना. आनीक प्युअरली प्रॉपरली एक स्टेटमेंट ऑफ फायनान्स आनी अकाउंट आनीक प्रेजेंट करून वोट ऑन अकाउंट घेवचो पडटलो. सो आय थिंक दॅट इज अ मोस्ट क्रुशल थिंग. जें बजेट स्पीच सारकें पावरफूल तयार जातालें, त्या बजेट स्पीचाकय म्हाका दिसता ह्या ऑर्डरीक लागून बरोच ब्रेक लागला. सो जेन्ना आमी म्हणटात की एक लॉ सेक्रेटरी स्टेट इलेक्शन कमिशनर आसचो न्ही, तेन्ना त्या लॉ सेक्रेटरीक असेंब्ली इलेक्शनाचे कित्याक पडिल्ले, जाल्यार ह्या खातीर, कारण बजेट तर प्रेजेंट करपाक जाय 31 मार्चा पयलीं. आणि जर बजेट प्रेजेंट केलें तें इलेक्शना पयलींचें जर लास्ट बजेट आसत जाल्यार ताचो गाजो वाजोय तितलोच व्हड आसतलो आणि जर गाजो वाजो व्हड आसा आणि जर हो कोड ऑफ कंडक्ट इतलो वाडलो आणि ऑब्वियसली सद्याची परिस्थितीन एक गजाल तर सामकी स्पश्ट आसा की मार्चाच्या 31 तारीख मेरेन तरी आनी कितें तरी करून इलेक्शन कंप्लीट करप शक्य ना. सो कोड ऑफ कंडक्ट उरतलो. सो असेंब्ली सेशन जरी जालें आणि जर बजेट मांडपाचो वेळ आयलो जाल्यार तें बजेट फक्त स्टेटमेंट ऑफ अकाउंट फायनान्स आणि घडये वोट ऑन अकाउंट आणि मागीर पळोवया अशीच परिस्थिती आसतली. किती करता मुख्यमंत्री तातूंतल्यान मार्ग कसो काडटा तेंय पळोवया. पण आमी इतल्याचेर थांबतात. हाचो उद्देश आशिल्लो ही सुप्रीम कोर्टाची ऑर्डर जी आमच्या राज्या खातीर आमच्या लोकशाही खातीर अत्यंत म्हत्वाची आसा ताजे म्हत्वाचे भाग तुमच्या मुखार दवरप. मुकेश, थँक्स अ लॉट फॉर जॉयनिंग मी. थँक्स अ लॉट ऑल ऑफ यू फॉर जॉयनिंग मी ऑन दीस ब्रॉडकास्ट. पळयत रावात प्रुडंट. नमस्कार.